The next clause, clause BA. We are doing section 41, subsection 1, and this is the third clause there, BA. Without an order from a magistrate and without a warrant, a police officer may arrest any person against whom credible information has been received that he has committed a cognizable offence punishable with imprisonment for more than 7 years or death. Clause BA, which we are now doing, is complementary to clause B, which we just did. There we were talking of those cognizable offences where the punishment was up to 7 years. Now in this clause we are talking of those cognizable offences where the punishment is more than 7 years. For such offences, if there is credible information regarding commission of the offence, and secondly, the police officer has reason to believe that this person has committed the offence, then he can arrest that person. The main point of difference or distinction between clause B and clause BA is that whereas in the preceding clause it was necessary that the police officer was satisfied that the arrest was necessary, in clause BA that requirement is not there. Only the first two requirements are there, and if these two conditions are fulfilled, then the police officer will be permitted to make the arrest. So this distinction needs to be kept in mind. And also the other distinction is that in clause B we are talking of lesser cognizable offences, in clause BA we are talking of more serious cognizable offences. Then there is clause C, which permits a police officer to arrest without a warrant, without an order, a proclaimed offender. Any person who has been proclaimed as an offender, he can be arrested without warrant. In clause D, the police officer is permitted to arrest a person in whose possession anything is found which is suspected to be stolen property. So a person in whose possession stolen property is found, he can be arrested. And there must be a suspicion that it is this person who has committed that offence. Clause E. A police officer may arrest a person who obstructs a police officer while in the execution of his duty or who has escaped or attempts to escape from lawful custody. And lastly, a police officer may arrest a person who is reasonably suspected of being a deserter from the armed forces of the Union. Anybody who is suspected to be a deserter may be arrested by the police officer without any warrant or order. Now we will see the law relating to section 41(1) clause B. We can recall that 41(1)(b) deals with those cognizable offences where the prescribed punishment is up to 7 years of imprisonment, no more. In those cases, in such cognizable cases, routine arrests cannot be made. To understand this concept, we will go through a very important case decided by the Supreme Court in 2014 by the title Arnesh Kumar versus State of Bihar. In this judgment, the Supreme Court made several observations and gave several directions for the police officers as well as for the magistrates. At this point, since we are dealing with the requirement of making an arrest, we will be dealing only with those provisions which relate to the police officer. The Supreme Court says in this judgment that no arrest should be made only because the offence is non-bailable and cognizable and therefore lawful for the police officer to do so. Every cognizable offence, as we can see from section 2 definition section, In case of a cognizable offence, the police officer can arrest without a warrant, without an order from the magistrate. So it is lawful. But the court says that just because it is lawful, arrest should not be made. Existence of power to arrest is one thing. Justification for its exercise is quite another. Yes, since it is a cognizable offence, there exists a power with the police officer to arrest a person, but there must be justification also for exercise of this power. And therefore, this sentence needs to be kept in mind. Existence of power to arrest is one thing, but justification for its exercise is quite another. No arrest can be made in a routine manner. No arrest can be made in a routine manner on a mere allegation of commission of an offence. No arrest should be made without a reasonable satisfaction, reached after some investigation as to the genuineness of the allegation. Just because there is an allegation, arrest cannot be made. There must be first some investigation. And on the basis of the investigation, if the police officer reaches a satisfaction, then he can make an arrest, not before that. Under section 41(1)(b), an accused person cannot be arrested only on a police officer's satisfaction that such person had committed an offence. Even if the police officer is fully satisfied that this is the person who committed this offence, that is not a sufficient ground for arresting that person. Some more satisfaction is required. And what is that satisfaction? The police officer has to be further satisfied that arrest is necessary for reasons given in subclauses A to E. We just now went through these reasons. One or the other of these reasons must be there. Then and then only arrest can be made. In pith and core, the police officer, before arresting, must put a question to himself. And what is the question? He should put a question to himself. Why the arrest? Why should he arrest? Is it really required? What purpose will it serve? What object will it achieve? These questions should be put by the police officer to himself. And if he is satisfied with the answers, then and then only he should go ahead with the arrest, not otherwise. The law mandates the police officer to state the facts which led him to come to a conclusion covered by any of these provisions. Those 5 reasons. This is the mandate of the law, that he has to state the facts which have led him to come to the conclusion that one or the other of those 5 grounds are there for making the arrest. When an accused is produced before the magistrate, the police officer is required to furnish to the magistrate the facts, the reasons and his conclusions for arrest. And the magistrate in turn is to be satisfied that the condition precedent for arrest under section 41(1)(b) has been satisfied, and it is only thereafter that he will authorize detention. Magistrate must also be satisfied. Then and then only arrest should be made. The practice of mechanically reproducing in the case diary all or most of the reasons contained in section 41 for effecting arrest must be discontinued. The Supreme Court has made this observation that there is a practice of mechanically reproducing in the case diary the reasons which are required to be given in section 41(1)(b). But this mechanical reproduction is not sufficient. And thereafter, the court says that the failure to comply with these directions shall, apart from rendering the police officers liable for departmental action, will also make them liable to be punished for contempt of court to be instituted before the High Court. So the Supreme Court has given a very clear direction that in case a police officer fails to comply with these directions, A contempt of court petition can be filed against him before the High Court, and he can be punished by the High Court if he fails to comply with these directions. And now let us reach a conclusion as regards arrest, specifically under Section 41, subsection 1, Clause B. Please remember, we are talking specifically of Clause B of 41.1. There are two requirements before making an arrest. Firstly, the police officer should have reason to believe, and this reason to believe has to be formed on the basis of information and material. And what reason? He believes that the accused has committed the offense. So he has to be first satisfied that this particular person, this accused, has committed this particular offense. And obviously that offense must be cognizable, and that offense must be punishable with an imprisonment of up to 7 years. This is the first requirement. But the second requirement is more vital and more stringent and more akin to Article 21 of the Constitution. It says the police officer must be satisfied that the arrest is necessary. Not only that the arrest is lawful, that is one thing. Arrest is lawful in every cognizable offense. That is not sufficient. He has to be satisfied that the arrest is necessary, and necessary for one or more of the purposes which are envisaged by the subclauses A to E of Section 41(1)(b). There are 5 purposes which are mentioned in these subclauses A to E, and the police officer has to be categorically satisfied that one or the other of these 5 subclauses are applicable in this case. Then and then only he can make an arrest, not otherwise.